This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, this is Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I really do appreciate everything you do. It's my mission to keep you informed, and you help a lot by subscribing, by contributing, by doing the things that you do to help me stay able to do this. So I want to thank you in advance. I have a very big privilege today, and that is to have Chuck Michel, who is the volunteer president of the California Rifle and Pistol Association. I'm very grateful for his service in that regard. He's also a crackerjack attorney, and I'm not going to have him on the screen when I say this because he'll get a weird smile on his face, but he's about the brightest man I've ever met. So don't tell him I said that. I don't want him to get a fat head. Chuck, thank you very much for joining the show. I appreciate it. You didn't hear any of that.
No, hey, I'm just a guy from Jersey trying to get by, man.
Yeah, I know it. You're the guy in the know, brother. I'm just a dummy who brings you people on here. I learned a long time ago, you don't have to hang around smart people. All right, not to be smart, just hang around smart people. So I'm hanging around you. What's going on in California in particular with the Supreme Court maybe and with our Second Amendment fight?
Well, to give you a little context, everybody knows 10 years ago, we got the McDonald opinion out of the Supreme Court that said that the Second Amendment restricts state and local governments from infringing on our Second Amendment rights. And 2 years prior to that, we had the Heller decision that said that the Second Amendment does protect an individual, not a collective militia right to keep and bear arms. So ever since then, lots of different groups have been trying to get back to the Supreme Court to get a decision from them about what the appropriate standard of review is when you're evaluating the constitutionality of a gun control law. We've challenged all kinds of laws during that period, and most of my litigation has been done in the Ninth Circuit, where unfortunately you've had a bench, a group of judges in the Ninth Circuit who were very hostile to the Second Amendment because they were very liberally inclined, let's say. And so the Ninth Circuit has historically, since 2010, bent over backwards intellectually to try and uphold gun control laws, no matter how big of an infringement they are or how poorly justified they were by the government. Thankfully, because of the Trump administration, the composition of the Ninth Circuit has changed. And also the composition of the United States Supreme Court has changed. So we have judges who are more inclined to understand the importance of the Second Amendment and respect it. And they're more inclined to hold governments to their appropriate burden of proving that a law that they pass actually does what they claim it will do and accomplishes some legitimate governmental purpose without unnecessarily infringing on your freedom to choose to own a gun, defend yourself or your family. That's the context for some of the lawsuits that the CRPA has filed, and we're thankful to the NRA for some financial support for those lawsuits that got a lot of press recently. The first one was the Duncan Case, which is the case that challenged the ban on importing and possessing magazines that can hold over 10 rounds. We've had a ban on the importation for decades, but the ban on possession only kicked in as a result of the passage of Prop 63, which was Gavin Newsom's, essentially it was the launch of his campaign for governor. It was the way he generated name recognition for himself across the state by pushing this proposition, which had a number of different gun control components, one of which was the ban on the possession of those magazines, and one of which was imposing a requirement that you have to get a background check before you can buy ammunition, and you can't buy ammunition by mail order anymore. So those were the biggest challenges of Prop 63 and what became Gunmageddon a couple of years ago, became commonly known as Gunmageddon. We filed the Duncan case challenging the magazine possession ban, and we won. We got a glorious opinion out of the San Diego court. An injunction was issued. And for a full week, what's now become lovingly known as Freedom Week, people were able to import magazines into the state, and hundreds of thousands of people did import over 1 million magazines. California cleaned out the inventory of these magazines, these wonderful little self-defense tools, from all across the country, and before the Ninth Circuit stayed the importation and said you can still possess them, but you can't import them while we consider this appeal that the state immediately appealed. That argument that the ban on the importation and possession both are unconstitutional was just heard in the Ninth Circuit before a 3-judge panel. And because of the new composition of the Ninth Circuit, we're actually quite hopeful that that ruling that the importation and possession law of banning the possession of magazines that hold over 10 rounds will be, the lower court's decision will be upheld, and the law will be held unconstitutional. The second side of that, the flip side of that, was the challenge to the magazine background check requirement and the ban on the purchase of ammunition by mail order. In that case, we also won at the trial court level. Unfortunately, the state had its request to the Ninth Circuit ready, and they immediately went to the Ninth Circuit and asked that the injunction on that law be stayed. So we only got basically Freedom Day. We got one day where you could buy ammunition by mail order and could go into a gun store and buy ammunition without getting a background check. Now the Ninth Circuit has a stay back in place. So we're fighting that stay. We're looking to get that injunction put back in place. And there will be another hearing coming up, oral argument, in front of a Ninth Circuit 3-judge panel. Now, on that case, the Rody case, challenging the requirement that you get a background check to buy ammunition and the ban on buying ammunition by mail.
Okay, so if you're not a legal scholar, which I fall into that category of not a legal scholar, and you know that, this can be somewhat challenging to follow because you've won and then you didn't and then you didn't and you didn't, and you kind of have this seesaw effect going back and forth. Part of that, it seems, is that it sounds like, who was I talking to the other day? We were having this conversation. I think it was Sam, that there were two things going on sort of simultaneously. There's the actual cases to determine whether these restrictions are constitutional, and then there were the requests for an injunction while the cases were being heard. Am I getting that right?
Yeah, well, remember, you go from the district court to the Court of Appeals. Potentially, there's another step for an intermediate en banc review, and then you go to the Supreme Court.
Right, okay.
We started in the district court. The district court issued an injunction in both cases, struck down those laws as unconstitutional, issued glorious, over 100 pages, opinions, rulings, constitutional works of art, okay?
Yeah, I read them. I agree with you. I mean, they ought to be taught in every class, every civics class
fantastic.
in the world. Yeah, they're amazing.
It's a primer on the Second Amendment. It really ought to be required reading, because this judge, it's not just legalese. The judge made it real, and that's probably because his family has some background in the Cuban Revolution and has seen some tyranny up close and personal, I think. So he's got a little personal experience. Anyway, we got the injunction in the trial court level, but the state appealed to the Ninth Circuit Court of Appeals, and the Ninth Circuit issued a stay over the trial court's ruling. So it's a higher court overruling a lower court and saying your injunction is going to be stayed. We're not going to strike this law down until after we finish hearing the appeal. So
with the ammo law, for example, is the case still being heard by Judge Benitez at that level, or is it now being heard by the Ninth Circuit in appeal?
Good question.
Yeah, well, I don't have a good answer, though. So that's
you have to keep in mind the difference between a request for a preliminary injunction and a request for a permanent injunction.
I see. Okay.
If you file a case and you don't want to wait until the end when there's a judgment and potentially a permanent injunction, then you seek a preliminary injunction before you go through the entire process of the lawsuit and get to the point where you would ask for that permanent injunction. And that's what we did. We asked for a preliminary injunction in both cases, the Duncan case and the Rody case, and this judge gave it to us. Now, typically when they do that, that's a very strong indication that you're going to win at the end and you're going to get that permanent injunction. But we haven't gotten it yet in the Rody case. So we're still litigating in the trial court to get that permanent injunction. The state may try and stay that too, may try and freeze the proceedings in the trial court while it appeals the preliminary injunction in the Ninth Circuit. But we haven't gotten to that point yet. Right now we're going to file briefs and have an oral argument on the preliminary injunction in the Ninth Circuit, while that trial court case is still there and may be active. Okay,
so it sounds like the trial court, the answer is yes, no, maybe. You don't know.
Yeah, as usual.
Right. Okay, that's the answer. Yes, no, maybe, I don't know. As it stands right now, that case is still sitting with Judge Benitez, but it could be by virtue of the power of the Ninth Circuit removed from him and brought to the Ninth Circuit. No. Is that what you're saying?
No, they can't take the.
I'm asking you layman's questions here because I don't know we have a lot of. I'm sure that most of my viewers are in the same boat I'm in.
Well, it's called an interlocutory appeal. What it basically means is an intermediate appeal while the case still goes on. The Ninth Circuit, they can't reach down and take it. Someone has to put it up to them. And the state can't take the whole case because there's no permanent injunction yet. There's no judgment in place. There's nothing to appeal on the whole case. The only thing that you can appeal right now is the ruling on the preliminary injunction. So that aspect of the case was appealed. Because that's all that can be appealed right now.
So we're still fighting the other case, though. The underlying case is still in court. We haven't.
Yes,
that has not yet been decided. So we're still
correct.
So all we lost was an interim step, which would have allowed us to avail ourselves of our Second Amendment rights to purchase ammo while the case is being heard.
Right now, theoretically,
did I say that right?
Yeah, basically.
Okay.
Now, in theory, and not to get too deep into the academic weeds here, but in theory, the state of California could now go out and spend $100 million to try and perfect all of the databases, all of which have huge error rates in them, and try and make it so that you could actually go in to buy ammunition, give your name, they would find your name immediately, determine immediately whether you were prohibited from buying ammunition or not, and approve the sale of the ammunition and get rid of most of the burden that is now placed on ammunition purchasers by this law. The problem with the law, and what Judge Benitez took a long time explaining and documenting and presenting the evidence on, is that many, many people, hundreds of thousands of people have gone in. They're lawfully allowed to buy ammunition. They've gone in and tried to buy it and have been denied because the database error rates are so high. And even worse, because that they're getting false negatives. They're getting denied even though they're eligible. Even worse, though, and this frankly is the more sinister and subtle little agenda that, it's a big agenda, that the gun ban lobby pushes. They know that if they make it hard and expensive and they put a lot of red tape in place and they make you have to jump through a lot of hoops in order to participate in the shooting sports or to choose to buy it, people will walk away.
Yeah.
Because they're not hardcore enough. They're not that engaged necessarily, and they're trying to scare those people out of the shooting sports. It's like, putting an abortion clinic 500 miles away from where someone might want to try and go get an abortion, or making it impossible to publish a newspaper. There's ways to chill your exercise of any right, and a government that doesn't like that right does what it can to scare people away from it and to chill their ability to exercise it.
So if they can't ban it outright, they make it more difficult to do, to the point that most people who aren't seriously engaged in that right will just abandon it.
They red tape it to death.
They red tape, death by 1,000 pieces of red tape, basically. Wow. Well, where does that leave us at this moment with these cases? I just want to be clear. I think you answered that question two different ways, but I want to make sure I understand it. Where does that leave us with the magazine ban and the ammo restrictions? Okay.
They're both in the Ninth Circuit Court of Appeals. One has been argued in front of the 3-judge panel, so we're waiting for a decision on that. And the other has had a briefing schedule, and an oral argument date will be set soon. That's an expedited schedule, so it'll probably be in July or August. But now you throw into this mix the Supreme Court, because the Supreme Court almost had taken a Second Amendment case. We're trying to get the Supreme Court to tell us what the appropriate standard of review, the level of scrutiny that a gun control law should get when it's challenged by this under the Second Amendment in court. So the level of scrutiny, in other words, how much deference you give to a legislative body can make all the difference in whether or not a law survives and passes constitutional muster or not. So, for example, if the legislature passed a law that said you have to leave your lights on 24 hours a day, and they said the reason for that is because it's dark outside all the time, day and night. If you give the government too much deference, a court will look outside, see the sun shining, and say, well, we're not going to second guess the legislature.
They told us it was dark, so it must really be dark. Okay.
Right.
Yeah.
So if the legislature says the lights have to be on all the time, who are we to say that the sun is out? Well, that's what they've been doing with a lot of the Second Amendment challenges. They've been saying, the legislature has said that this is for public safety and that this doesn't infringe on the rights of law-abiding gun owners and who want to choose a gun because they, for God forbid, for the joy of shooting, they discover the joy of the shooting sports, or to defend themselves or their families. They just defer to the legislature and uphold these laws. That's not how it's supposed to work. That's not what the Heller or the McDonald case said the standard of review should be. And so we want to get the Supreme Court to clarify that this, basically, to put it in layman terms, to clarify that the Second Amendment has teeth. So the Supreme Court had taken the New York State Rifle and Pistol Association versus City of New York case, which challenged a law that banned you from taking a gun that you had in your house outside of the city, effective, basically. But unfortunately, the Supreme Court decided that case was moot because the city, being the shrewd little lawyers that they were, helped by the gun ban lobby's law firm, repealed the ordinance that banned taking those guns outside of your home so that the law wouldn't exist anymore, so that the challenge to that law would be moot. Unfortunately, last week, the Supreme Court agreed that, yes, because they repealed that law, the challenge is moot. So we didn't get to the issue of the appropriate standard of review. So then what happens is there were 11 Second Amendment cases lined up in the Supreme Court, all on hold, waiting for that New York City case to be decided by the Supreme Court. Now that the Supreme Court has basically said, it's moot, we're not going to decide it on the merits, one of those cases may be taken up by the Supreme Court to take the place of the one that they just got rid of by declaring it moot. So last Thursday, all 11 of those cases were considered in conference by the Supreme Court. What the Supreme Court does is they hold in-house conferences, internal conferences, every week or so, and the judges all decide whether or not to take a case. Remember, the Supreme Court doesn't have to take any case, and typically they only take about 2 or 3 in 100. And so they were addressing all of those 11 Second Amendment cases to see which one, if any, they would take now that they did not decide the New York City case. And so this morning we learned that they had not decided whether to accept or reject any of those cases last week. And they've trailed or postponed the decisions on all those cases over to their next conference, May 18th. And so, cross your fingers, because we want the Supreme Court to take one of those cases on May 18th and then use it to set the appropriate standard of review, hold the government to its burden of proving that a gun control law actually does something without unnecessarily infringing on our rights, and basically give us a hard reset on Second Amendment litigation, not just in California, but all across the country.
Somewhat of a Second Amendment renaissance, perhaps, if they were to do that. I have a couple of questions for you. One is with regard to, well, first of all, the standard of review. What is the appropriate standard of review?
Well, that's a really good question. And that might be something we need to spend another hour show on. But to put it in a nutshell.
Yeah. Because here's the reason I ask is because I hear this from people all the time. Why isn't the standard of review shall not be infringed?
Well, because you have to decide what infringement means. Is it infringed or not? No right is absolute. Remember, you can't scream fire in a crowded theater and those kinds of things that everybody knows. But so every fundamental right is subject to some level of scrutiny. So the question is, what's that structure going to be for that scrutiny? And in the First Amendment jurisprudence, I'm going to oversimplify, but
please,
you essentially have
I need all the help I can get.
Basis.
Right. Okay.
You have rational basis where they say, okay, the legislature says the sky is black all the time, and so we're going to defer. That's rational that they would require us to have the lights on all the time. We're going to defer to them. Then there's intermediate scrutiny, which applies a little more. It has to be a narrowly tailored law that accomplishes a very fundamental government interest. And then there's strict scrutiny, which is a compelling governmental interest and narrowly tailored law to specifically go after the problem that the interest that the government has identified. So those are levels of scrutiny. On the lower end, most things are upheld as constitutional. On the higher end, a lot of things may be struck down as unconstitutional. And then there is, just to make things interesting, because that whole rubric of the low, medium, and high level of scrutiny, and there's twists on that, as only lawyers can do, depending on the right that you're talking about. But the levels of scrutiny that were applied in First Amendment jurisprudence have really been problematic. And now the Supreme Court has an opportunity to just throw that all away when it comes to Second Amendment evaluations and go with originalism, which is essentially you decide whether or not the law was the type of thing that the founders would have tolerated when it was originally passed. And to do that, you look at the text, history, and tradition of gun control laws and of the things that were historically acknowledged to be tolerable, and decide if any particular law would have been tolerated by the folks who.
Okay, so this is my old man. I'm going to put on my old man hat here because I are one. I'm old enough to draw a Social Security check, so that makes me officially old. I'm a bit of a history buff. If you apply that level of, if you apply that measure, that benchmark, to just about any law, most taxes would go away because the founding fathers would see them as an unconstitutional levy against whatever. When you have to go pay a 10 or 15% levy on baked goods, or you have to pay 40 cents or $1.20 on fuel or whatever, most of those things would go away immediately when you look at what would the founding fathers tolerate. If you took any of the founding fathers and resurrected them today and brought them into our society today, they would be absolutely stunned and appalled and wonder why there hasn't been a second revolution to get rid of all this nonsense that has cropped up since then, not just with regard to the Second Amendment, but with regard to every aspect of life. So you got me on my soapbox. I'm sorry. So my humble view is that if the court decides to adopt that view, which seems to be the view that Scalia had in his Heller opinion, that there's a very good chance that the vast majority of restrictions on the Second Amendment can be litigated out of existence. Or am I reading that incorrectly?
I'm inclined to agree with you. And let me say, I hope that my 600-page gun law book for California gun laws gets winnowed down to about a 10-page brochure, because we are so thorough in getting rid of some of the baloney. I'm
going to go further. Much as I know that book took a lot of your life to write, I'm hoping it gets whittled down to a one-page flyer, or maybe even a half-a-page flyer. That'll be it.
But right. The other side is not conceding this by any stretch of the imagination, and that's why you've got Bloomberg supporting the Duke Firearms Law Center, and you've got all these historians, quote unquote, being paid to produce volumes and volumes of scholarship that demonstrates that all these gun control laws that we know never really existed before, they were common throughout history.
I looked in my wallet here, and I'm sorry. I thought I had a $50 bill. I don't. All I got's a $5. Okay, you just won, my friend. Here, I'll feed it through the computer. You just won the $5. You make a good. You want the 50? I don't blame you. I'll buy. I owe you a lunch or a beer or something, maybe both. Okay, so the reason why I did that is because you make a great shill. My next question, which I'm going to show you, so that I don't want. If you're watching this, I don't want you to think I'm fibbing to you. But there you go. You'll notice the next one of them was shall not be infringed. The other one was what? Cost on the top. First question. So there you go. These for the lay person, and that would be me. These lawsuits are incredibly complex, to my mind, and take a lot of time and a lot of effort and a lot of schooling, and it just seems like a continual battle that never seems to be completely finished. It's one battle after another, but the war never seems to end. There's a cost associated to this. What are these things? What does it cost to get Rody v. Becerra as far as it is, or take it all the way to the Supreme Court? What does it cost to fight these individual battles? Look, different firms obviously charge different rates. I'm into this because I'm an activist, not just a legal. Yeah, I know you. You're a nut like me. I get it. But still, there's a cost associated.
Yeah, my wife won't let me work for free, but we work for a lot less than market rate.
I know you do.
It's hundreds of thousands of dollars to get one of these cases to the Supreme Court, and at the Supreme, just the printing bill at the Supreme Court is $30,000 or $40,000 just to pay the printer to print the briefs out and submit them.
Oh my gosh, so I'm in the wrong line of work. I needed to have started a print shop.
Yeah, amen. Because it's specialty printing. You have to have it the exact right format that the Supreme Court wants it, and they have to have all the different copies. Anyway, the point is, it's not cheap. And one of the reasons it may get less expensive once we get that Supreme Court opinion that resets the bar on the standard of review. But right now, it's all complicated. This is custom one-off work. And this is a problem I've had ever since Heller came out. There's a lot of lawyers out there. Every lawyer, wants to go to the Supreme Court, or they think they do, until they realize what's actually involved in doing that and how much work it is. You have to shut down your practice for like 3 months and just prepare for that case if you really want to maximize your chances of winning. And you have to know such a broad spectrum of law. You can't just go in and litigate a Second Amendment lawsuit without knowing all the other law that applies to all the other rights that we have, because that body of constitutional law could come up at any time during your oral argument. You have to be ready for any.
As a layperson, I've watched oral arguments and listened to them, the recordings of them and so on. They go off on tangents, these judges.
Yeah,
they'll ask you a question on you're talking about this, and they'll ask you a question about some screwy thing over here. And if you don't know what you're talking about, you look like an idiot. You got to have that in your head.
Exactly. You have to be loaded for bear and every other animal that might be in the woods. So it's harder than people think. And then on top of knowing all this, you have to be a persuasive writer. And that is a skill set which is becoming less and less common out there. That's why first-year law school graduates are getting paid high six figures as a first year out of law school if they can write.
Provided they can write.
The art of persuasive brief writing, thoroughly researching and persuasively digesting and putting a brief together that a judge will take seriously and read and contemplate and hopefully agree with you on. It's not a completely lost art, but it's certainly harder to find.
Well, and it's like anything else. Not all attorneys are the same. We've been in business 12 years. We have 20,000 students, and we teach students throughout the state. So we're a relatively successful business. Before that, I had a real estate brokerage in Mission Valley here in San Diego. We did very well. And so I've done, a number of businesses that my wife and I have owned over the years. And as a result, as you might imagine, I've had to hire business attorneys and those kind of things. And those are all transactional things. You hire an attorney because you need an agreement for this, or I just recently paid an attorney to draft an advertiser's agreement because I had a couple of sponsors talking to me about potentially sponsoring GunGuyTV. And I thought, well, I don't have an agreement for that. And they said, oh, we don't need an agreement. And I thought, yeah, this is not this is not my first rodeo. So I paid an attorney to do that. Well, those are cobbled together not out of pieces of other agreements, because we know that an arbitration clause is an arbitration clause is an arbitration clause, and so on. So it's not generally, while there's some customization, it's basically templated, and the attorney customizes it to what you need. That's not what we're talking about here. And the attorney who can easily do that cannot necessarily do what we're talking about here, and they may not be skilled enough, bright enough, know enough, schooled enough, or whatever, or experienced enough to do it. So it's a whole different world, is it not?
It is not. Constitutional litigation, especially Second Amendment constitutional litigation, where you're in a hostile environment, lots of judges don't want to go your way. It is not plug and play. It is not copy and paste. You can't just, take an old brief and put a new name on it and file it. Every single case has a whole set of unique issues that have to be addressed individually if you want to win. And not to mention packaging the evidence in a case to prove your case when there are factual disputes. Some of this is a pure legal dispute, but in the Rhodey case, for example, there was a ton of factual development that had to be done about what happens when people actually go into a gun store and try and buy a gun. The whole process, try and buy ammunition. The whole process of purchasing that ammunition and all the databases that the information gets sent to, and what happens when those databases send information back, and how a person ultimately gets accepted or approved or denied to buy ammunition. That was a huge undertaking to get all that information and digest it and put it in the form of evidence that could be considered by the court. And Judge Benitez did a great job pulling all that together and presenting it in his opinion in a way that we think is going to be very tough for the state to overcome.
I'm not a lawyer, but the one nice thing I love about his opinions is they tend to be written in relatively plain English. So if you read them and you've got a sixth grade education, you get his point rather easily. It's not that tough to do, which is a great testament to his ability to write very effectively and creatively. So you're looking at something that takes hundreds, if not thousands, of hours of time and $500,000
to get to the Supreme Court.
Supreme Court. And that doesn't count actually litigating it in the Supreme Court once you're there, does it?
It depends on the complexity of the issue. I don't want to say it's all the same, but depending on how complicated the case is, depending on how many amicus get involved, friends of the court filing briefs, things like that can make the case more or less complicated, and that makes it take more or less time. And time, a lawyer's time and advice is or her stock in trade, as Abraham Lincoln was prone to say.
Yeah, and he was a nice guy, so he failed in his practice a couple times. So at some point or other, you want to really be able to get that money and get your bill paid. So that's the next question then becomes, we now know that these things are expensive. Where does that money on our side, we know where it comes from on the other side, the Bloombergs of the world are pony up money right, left, and sideways, because he blew $1 billion on his failed presidential campaign and it didn't dent him. Does that give you an idea? Where does the money come from on our side to fight these things? It's got to come from someplace.
Well, historically, it comes from specific donors who may have an understanding and appreciation of the need to do these kinds of lawsuits. And there are a lot of those. And they may donate directly to one of the plaintiffs or to the law firm that is running the show, or to the NRA or the CRPA or one of the other groups. And then those groups then funnel the money, hopefully, to fund the lawsuits. In California in particular, the problem is that I don't think it's a secret that the NRA's having some financial.
No, it was in the news today. Right. No, it's not a secret. It's out there. It was in the news today that they had to cut salaries by 20%, and they're getting beat up on by every quadrant. And
so they're having a hard time funding things at the level that they used to. And so the CRPA is really working to step up its fundraising efforts and make people understand that there's this breach, so to speak, that the CRPA is trying to step into to fund all these lawsuits, not just the ones that are going on right now. And we only talked about 2. There's about a dozen, but there are, like I said, I want to get that book down from 600 pages to a couple of sheets.
I know you do. And the reason why I brought up the funding issue is it should be blatantly obvious to the most casual of observers, but I'll spell it out anyway. It is incredibly common for me to get comments, emails, instant messages in Facebook or whatever that ask the rather general question, why isn't somebody suing about this? Well, if you're watching, somebody is. This gentleman is, along with CRPA and a lot of other people. But the cost is daunting. It really is. And so it's one thing to say, why doesn't somebody sue? And it's another thing to get your wallet out and help somebody who is suing get the job done.
Yeah.
Each of us in the Second Amendment community, and again, I know I'm on my soapbox again, so you're going to have to forgive me. It's my show. It's my bloody show, and I can be on my soapbox if I want, okay? I'm the one that pays the bill around here, so I can be on the soapbox. It's one thing for us to complain that the laws are unconstitutional and they're restrictive, and then to say somebody ought to be doing something about it. It's another thing to look in the mirror and realize that you're the somebody. I'm the somebody. Each of us is the somebody that should be doing something about it. I'm not an attorney, nor do I play one on YouTube, or nor do I wish to be one at the ripe old age of 60, which I'm not going to mention. Thank you very much. And so I'm not going to go back to law school and become an attorney so I can fight this battle. I don't need to. There's one right here on my show who's doing a bang-up job, and his law firm does an excellent job. What I can do is I can support his efforts. I can do it financially if I have the wherewithal to do that. Some of us do. Some of us don't. I can do it by doing what I'm doing right now. I can help get the word out. You'll notice it's a very strange thing to me, Chuck, that if I look at, if I'll do this today, you and I'll do this, and then it'll get posted, and it'll get thousands and thousands and thousands of views in relatively no time at all, for which I'm very, very grateful. I'm glad to have that level of a platform and have it take off like that. And then Rick will do a video with you and talk about the exact same thing on the CRPA YouTube channel, and it'll get, in a period of a week, it'll get 300 views or 700 views. And I go, why isn't everybody subscribed to that? I watch them. So
we're working on that, and you're helping.
And I'm working on that, okay? So if you're watching this, before you say anything, Chuck, if you're watching this and you're not subscribed to the CRPA channel, I'm going to put a link in the description so that you can do that. Yes, come here and get information here, please do. But go someplace, go over there once in a while too and get information there, because oftentimes it's posted before you'll see it here. Anyway, I'm sorry, go ahead.
If only I could get Kim Kardashian to give me a plug like that. You know what I mean? I don't know the rhyme or reason for why certain people have influence and become influencers and others don't.
I don't know.
No matter what subject matter is. It's funny, when I first started posting on Facebook, I was posting all this very valuable information about lawsuits, and then and I wasn't getting very many likes or friends or whatever. And then I posted a picture of a cloud that kind of was shaped like a gun, and I said, let's have a caption contest. And suddenly I had 3,000 people trying to come up with the name for the caption for the cloud picture. I mean, I don't know what the rhyme or reason is to this. We've got social media people that we consult with all the time trying to develop this. But the reality is you can only help. You can help with money. You can help with your time. And you can help by leveraging influence. And that's what you're doing, Bill. And we appreciate it very much that you're helping us get the word out so that people will understand what's involved in doing this and how much is at stake.
Oh, my gosh.
We really are on the cusp. We are on the cusp of turning the tide and taking back a lot of our freedoms. You know, I'm usually California-centric. But
and for me too, because I'm here, and so are you. I get it. But, at the same time, we have all these brand new gun owners, many of whom, I mean, I've heard from some of them who have sent me notes and so on, who watch the show. Thank you. I'm grateful for that. And just briefly back to your earlier comment. I have, to be honest with you, I have absolutely no idea why people enjoy watching my show. I'm just grateful that they do. I'm not going to try to figure it out. I'm not smart enough to do it. I'm just grateful that they do. I probably wouldn't watch it, so I don't know why they do, but I'm really grateful. All right, back to what I was saying, though, is I'm hearing from these new gun owners who were stunned when they went to go buy a firearm during this mess, and they had to wait 10 days. Or they had to go through this background check, or they didn't have the right kind of California driver's license because they didn't have a real ID, or they didn't, or I'll tell you in a couple of cases, they couldn't go pick up the gun because the gun store had been told to close. Now, they purchased their gun, their 10-day wait is over, but they can't go pick up the gun because the gun store had been told to close, and they didn't have any choice, so they closed it down. And then when they reopened, they were able to go get their gun. So now these folks who were ambivalent before, or perhaps very much on the side of gun control before, now realize what they've got. It's a very interesting experience chatting with them and finding that they've now it's been a wake-up call for a lot of them. And there may be someone like that watching right now. So if that's the case and that's you and you're watching right now, I want to urge you, the way to keep this from happening to the next guy is to get involved with CRPA, if you can have the financial wherewithal, contribute. More than just, you can join and be a member or a life member or whatever, and that helps keep the lights on, but it doesn't pay the bill for these lawsuits. It doesn't even come close. It barely keeps the lights on. So it's important that we're contributing. As Chuck said, you can contribute with your time. You can contribute with your money if you've got it. If you don't have money, what are you doing? You're doing the same thing I'm doing. You're at home. Okay, contribute some time, right? If you're not working, you got all kinds of time. It's valuable. And you can contribute by spreading the word. Now, I have a bit more of a platform than a lot of folks, but that doesn't mean that others can't tell their friends or use your Facebook account and comment on it. Spread the word a little bit, because if we don't, I've been at this a long time, okay? Not on YouTube specifically, but I've been teaching for 20 some odd years, and I've actually been teaching people how to shoot for most of my life, but I've been teaching professionally for 20 some odd years and trying to educate people along the way. I don't think in my memory in this fight we've ever been as close to victory as we are right now. Ever. We're so close. And if we dry up the money well right before we win, or we stop supporting right before we're right there, we've snatched defeat from the jaws of victory. We've got to keep fighting, and we got to stay in the fight. And that means we got to help Chuck do that.
What terrifies me is that the unqualified lawyers, or the lawyers without the appropriate resources, they underestimate what's involved in doing these things. They see this shot at going to the show. They think they might be able to get a case back to the Supreme Court, and they file these very poorly prepared lawsuits because they think they can just staple the Heller decision to their complaint and win and mail it in. It's not going to be that way, even if they reset the standard of review, because the forces that are lined up against us are well financed by Bloomberg, and they have all these academics that are coming up with ways to argue that the Second Amendment doesn't mean much. And so it's still going to be a slugfest in court, and it's going to take good lawyers and financing to take that success and hang on to it.
And I want to make sure that if you're watching too, just so you know, I may sound like a shill for CRPA. I'm not. CRPA doesn't pay me a dime. I give them money, but they don't give me any. And I don't want any of their money. I'm a life member of CRPA. I support CRPA. I support Chuck and what he's doing. And I'm happy whenever I have money to donate money to the cause. I do this because I'm passionate about it. I don't make money on YouTube. Now, that's not true. I do make some money off YouTube, but it doesn't cover the cost of what I do. What it does is it takes away a little bit of the pain of my wife and I funding the rest of it. And that's, as Chuck said, she won't let me work for free. Okay, but nevertheless, it does cost more to put on GunGuyTV than I actually generate from YouTube and the other things. And that's fine. I don't mind that. And that's why I don't say to CRPA, hey, can you pay me for this interview? Because that takes away money for the fight. That's a way that I can kind of contribute a little bit of money without necessarily writing a check by helping them get the word out. So I don't want to come across as if you think I'm a shill for the organization. I'm not. I'm a heartfelt supporter of the Second Amendment and of this fight. And if you think otherwise, you're welcome to contact me and ask me about it.
That's how I feel too. Look, I've, as I said earlier, I'm not just a legal advocate. I'm an activist. I'm a true believer. Okay, my chocolate lab's name is Heston. Right.
I love it. That's hilarious. Charles, okay. Chuck Heston would love that.
I give more pro bono time to the gun rights movement. I'm not paid to be the president of the CRPA.
No, he does volunteer.
I believe in it. If I only wanted to make money, I would have stayed at a big firm and spent my whole career fighting over money with other lawyers who were fighting over money.
Oh, let's make it worse. If you only wanted to make money, you could work for Bloomberg, destroying the Second Amendment and make a fortune.
The point is,
right?
There's things that mean something. There's things that you take heart in. There's things that give your life a purpose, that maybe you leave a little legacy. I have 2 sons that I want to live in a world where they have the freedom to do a lot of different things, including keep and bear arms. And so I don't want, there's groups out there, and I don't want to wax too philosophical into, socialists and communists and, tyrannical governments.
I don't care. Wax away, man. It's my show. You do what you want.
I mean, there's a argument going on about how we should live our lives and who should choose and whether and how big of a role the government should play in how you live your life and what kind of choices you can make for yourself. And I think that's really not a good thing for society. It's not a good thing for humankind.
No.
And I want to do what I can to preserve our individual liberties.
Freedom.
To choose for ourselves.
Freedom. We're losing it. We're losing our freedom. And we've been losing it for a while. We're losing it one piece at a time. And we'll probably have to get it back incrementally. We're probably going to have to fight for it one piece at a time. This stuff is hard. It's not easy. It's hard. It's hard, and it's long, and it's not ever going to be easy or short. So if you grew up in the microwave generation and you want what you want when you get it and you can't figure out why these battles haven't been won already, well, I'm telling you, just take some advice from an old guy. This stuff is going to be, this is a long, hard, costly battle. And this man on my show right now has been fighting this battle for a long time. And it's cost him a lot. It's cost us all a lot. So I urge you to join the battle and understand that it is hard and it's long. No illusions. It isn't going to be easy. We're not going to win all at once. Even if the Supreme Court takes a case and clarifies the standard of review and says the standard of review is so stinking high that 99.9% of all gun laws are going to fall, doesn't mean that they fall at that moment.
Right. You have to go through the motions, individual battles. And you know what?
And hundreds of thousands of dollars for each stinking one.
And the other side is fighting dirty, by the way.
That's not news.
With the whole NRA blacklist and the effort in some states to discourage banks or insurance companies from doing business with FFLs or
Wells Fargo. It was a news story about Wells Fargo today. About that.
All of that stuff.
Yeah.
It's part of, there's a PR campaign, obviously, to demonize gun owners and shame them. But the business side, where they try and put that pressure on corporations to not have affinity deals or give discounts to, NRA members or those kind of things, that's really a whole nother level of warfare, a cultural warfare. That is kind of new in our situation, and it's another hill that we have to climb.
It's the cancel movement. I mean, I don't know how many times I have concealed carry coverage because I've carried a gun since, 3 days before dirt for 40 some odd years. And I have that coverage. And the insurance company that underwrites that has changed about half a dozen times because they say, well, we don't want to cover anything associated with guns. And then the company has to race out and find a different insurance company that wants to do that because the insurance companies are being pressured not to cover anything associated with firearms. The banks are being pressured not to underwrite any loans for any firearms-related business or firearms-related advocacy. YouTube, how many times has my channel been threatened with being completely deleted or videos removed or whatever? whatever. Social media, they come after you for that. How many gun channels have been absolutely removed because YouTube doesn't like the content? Now, they've backed off of that a lot, but who knows? That could come back tomorrow. So
a lot of what we're doing now is using the First Amendment to protect the belief in the Second Amendment. Look at they try to shut down gun shows, and we had to challenge that on First Amendment grounds because they didn't want to let a legitimate event occur on taxpayer paid for property, which, by the way, the people who went to the event are all taxpayers.
Yeah.
Public venue, which the state has monopolized. They don't let just any private company come in and build a fairgrounds. They want to own that venue so that they can make the money off the events there. But then they wanted to try and stop a legitimate business from having an event at that fairgrounds that had been there for 30 years. And we had to go in on the First Amendment, using the First Amendment to shut down that effort to ban those shows.
Well, and here's
like that with gun stores, gun ranges. Yeah. It's all part of the plan. Well,
and even with the gun ranges, I mean, oftentimes I know the P2K Range here in San Diego County, they're off in the East County over near El Cajon. They've gone through a lot because the county has come in and over the years, now it's calmed down quite a bit, but over the years the county has come up with every little nitpicky little thing that they needed that range to do differently. And every nitpicky little thing cost them 25 or 30 or 40 grand to do. They got them because of their lighting wasn't up to code for the particular area they were in. Never mind the fact the range has been there for 97 years.
Right.
So now they had to spend 30 or 40 or 50 grand replacing the lighting. And then they didn't like the way that this sign was, and that cost them another. So all they were doing was bleeding that range to death in the hope of killing the range. And it was so overtly obvious that even the county officials sometimes that came out and did what they did made it obvious without saying it. Somebody can make it obvious what their intention is without necessarily being, saying it plainly, made it very obvious that their goal was to close that range. They couldn't jerk their license, but they could sure make it cost so much that it wasn't worth being in business. And to Dennis Roman's credit over there, and the board's credit, they've fought tooth and nail and they've kept that place there, which is stunningly difficult.
That's a strategy that's being used against ranges all across, not just California, but the whole country. We probably have 50 ranges that we're helping out right now with those kinds of issues, whether they go after them for noise or environmental regulation is the big one right now.
That's what's killing those people over there. Same thing.
Or safety claims. I love these. A lot of these things are contrived. I love when I had a case where the neighbor went in to show the city council. She had a cartridge and she said, "Look what they shot onto my property. This could have killed somebody." Okay. It's the cartridge.
That's an empty cartridge. Yeah. They shot it onto my property.
I mean, so that's what we're up against though, at all levels of the argument. The misinformation, the propaganda is just over the top. So,
well, and you mentioned the First Amendment, and this is my personal opinion. The Second Amendment, this is not my opinion, this is a fact. The Second Amendment exists for the sole purpose of ensuring that the other rights are safeguarded.
That's Charlton Heston. The Second Amendment is the first among equals.
And it's the one that's treated like the redheaded stepchild of all of them. We are attacked. Our First Amendment is attacked for the purpose of killing our Second Amendment so that the First Amendment can be destroyed. We watched these people in Michigan the other day, and they showed up at the Michigan Capitol because I think it was Michigan, because the governor there is a nitwit, and she come up with all these goofy restrictions. And some of the folks that showed up were armed. Okay, well, guess what? In that state, it's legal to do that.
Legal, open carry.
It's perfectly legal. It's open carry, and it's perfectly legal to carry at the Capitol. And if the legislature wants to make it illegal, they can do that, but they haven't. And so it's perfectly legal for those folks to do exactly what they did. Now, what's interesting is I read a story that those people, because of COVID-19, their temperature was taken before they were allowed to enter the Capitol. And yet the news story says that these armed people stormed the Capitol. Now, I'm having trouble envisioning people storming the Capitol and then queuing up obediently in the middle of their storming the Capitol and running toward the Capitol with arms so that they can have their temperature taken individually and be let in. The reality was, were they angry? Yes. They're losing their livelihood, their businesses, or whatever. Of course they're angry. But were they storming the Capitol? No. Did anybody get hurt? Not that I'm aware of. Did anybody shoot anybody? Not that I'm aware of. Did anybody pull a gun and threaten anybody? I don't know. If it's in the news, tell me, because it didn't happen that I'm aware of.
You know, if it happened, it would be.
It would be all over the news for days and days and days. And yet many are the news story that say these folks stormed the Capitol. No, they didn't storm the Capitol. My son asked me the other day, he said, "Hey, Dad, why do you suppose that they carried guns when they went?" I said, well, first of all, it's legal to do so. I mean, we're in California where it seems weird. But, you know, it's a great demonstration to over-the-top legislators that they work for us, not the other way around. And that if needed be, we do have the ability to resist. And it's a good idea that they know that. So I don't have a problem with what they did. What they did was entirely legal, and they obeyed the law when they did it, and they harmed no one. Anyway.
But part of that was, you know, look, we were talking a little earlier. This is part of a larger cultural war that's not just about the Second Amendment. They're attacking everything about, you know, the government's role in our lives. And part of that is really well illustrated by the whole suppression of politically unpopular or not even politically unpopular, just, you know, certain ideas that it used to be the cornerstone of the First Amendment was that if two people disagreed, you talk about it, you exchange ideas, you criticize each other's ideas, and maybe reach a consensus or persuade somebody. Now you've got this on campuses all across the country where a conservative speaker is going to come in and they're not going to let them speak. I mean, that's the kind of thing that's the kind of censorship that this country was very determined to not allow to take place. That's why we have the First Amendment, because our founders, just like they recognized the wisdom of the Second Amendment, they recognize the wisdom of the other bill, the rest of the Bill of Rights, including the first, that, you know, that free exchange of ideas, you're not allowed to stifle and just censor another man's thoughts.
Well, the whole purpose of the Bill of Rights was to ensure that rights were protected, minority rights were protected from a foolish, angry, or oppressive majority. So that the majority can't come in and say, "I'm sorry, but your opinion doesn't matter and you don't get to speak it anymore." So that the majority can't come in and say, "Well, since we're the majority, you don't have the right to keep and bear arms. Since we're the majority, you don't have the right to have representation before we convict you of a crime and throw you in the gulag. You don't have a right." That's precisely why we have those rights, is because the rule of the majority is typically tyrannical.
Right. It's the tyranny of the majority. If the majority ruled lunch, we'd have pizza every day. I mean, you can't count on the majority to make intelligent decisions all the time.
No, that's why we don't live in contrary to popular belief, we don't live in a democracy. We live in a representative republic. It's an entirely different structure, and there's a reason for that. Because if we lived in a democracy, we would be eating pizza every day, probably, or whatever the case. Anyway, we've gotten off on the weeds here. I apologize, Chuck. Is there anything else that we should know that is of interest at this moment?
Well, we have a lot of other lawsuits going on. That's probably best for another show.
Okay.
Keep your eye, the late breaking news, the things to keep your eye out for right now. We've got a motion to vacate the stay in the Rhodey case. If we win that motion, then the ammunition could be sold the old-fashioned way. It's not really the old-fashioned way. It's the way it's done in every state in the country, basically.
And was here for 100 and some odd years. Right.
And you could mail order it if we win that. So keep an eye. Even if we don't, though, don't lose hope. We will continue to fight that Rhodey case in the Ninth Circuit. And then we're watching the Supreme Court on May 18th, and that might get kicked again, so don't lose hope there either. But on May 18th, the Supreme Court will probably, actually, it's that Monday, whether that's the 14th or the 18th. They have the conference on the Thursday before, and then they publicize what they've decided on the Monday. Anyway, that Monday, we may know that the Supreme Court has taken one of those Second Amendment cases that it's holding right now, and that would be a good thing too.
Okay, now I'm going to ask you a political question, and then we're done. Without regard to what anybody might think about personalities and approaches and so on, we have a presidential election coming up. Is it important that Donald Trump is reelected? And if so, why?
I don't know who Joe Biden's going to pick for his running mate, but it's going to be the most anti-gun ticket in history, even more so than I think Hillary Clinton. And remember, Hillary Clinton is the one who said that the Heller decision was wrong because the District of Columbia ordinance, which required you to keep your gun completely unassembled, and you couldn't even have a handgun unless you get a license. Nobody had a license in decades. She said it was all about keeping babies safe. So the extent to which the Democratic Party platform and Democratic machine is terrified of and opposing your right to choose to own a gun, they know what the stakes are here. They've seen what the Trump administration has done in the last 3 years in changing the composition of the courts, and they know that changed composition is going to result in some more positive rulings, not just for the Second Amendment, but for limited government. Now, Donald Trump has lots of issues. I mean, I disagree with a lot of the things not so much the things he does, but the way he does them, let's say. I mean, he's your typical obnoxious New Yorker. I grew up in New Jersey, okay? I know them well.
Yeah, right. He's from Queens, for crying out loud. He sounds like he's from Queens. I get it. Okay,
so I get it, but that you can't just throw up your hands and sit this one out. The presidential election is going to be critical, and not just that, but the Senate and the House as well. I mean, you have to support him warts and all, or you're going to get creamed by the Democratic machine.
Well, and I'll tell you, you mentioned the Senate and the House. I mean, if Donald Trump's party does not keep the Senate, then kiss goodbye to the any new judges being right. approved that are of similar ilk to the ones he's approved already, which are tremendous, because Mitch McConnell has shoved those through like a vengeance and used all of his power to do so. If they lose the majority in the Senate, that goes away. If the House still maintains its current makeup, you can look for every kind of cockamamie, oddball investigation known to man to try to harm everything that we love or think is good, or any pro-gun stuff or whatever, for the entire term, and absolutely nothing else to get done. And so say goodbye to things like, I want to see constitutional carry, but I'd like to, in the interim, see a reciprocity agreement, a reciprocity bill actually passed. It passed the House a couple times, never got past the Senate. Now it has not a snowball's chance and where of passing the House because of Nancy Pelosi at all. If we can actually recapture the House with conservatives, maintain the Senate with conservatives, and have Trump sitting in the White House, nothing's guaranteed, but there's a really good chance that we could get concealed carry reciprocity across the country.
And a lot of other good federal bills that would stop the shenanigans that a lot of states like California are playing.
One of which, by the way, is a bill to protect Second Amendment organizations and firearms retailers and all this other stuff from all this banking nonsense we were talking about before. And it's actually being shoved through the Senate, but it's got not a chance in the House. So it's important. I see it as vital. If we don't reelect Donald Trump and get the House and the Senate because we sat on our hands, we're in trouble.
Hey, the last thing I would say is if you are or know one of those newbies that got that gun, and it's their first one, or maybe they're not as familiar, there's lots of opportunities for free or very, very low cost training. And I'm not advocating. I got to be careful because I say, get some training, and everybody says, you don't need a license, you don't need training, don't go. Yeah, it's a point and click interface. And if you're just doing some basic home defense, maybe you'd be okay. But I'll tell you what, if you get some training, then the odds of you being successful in defending yourself or your family and not having someone accidentally get hurt are increased. So, and plus you'll have more fun and you'll hit the bullseye more often. So, learn a few things and discover the joy of shooting. This is what I'd really like folks to discover out of this. It's fun to go to the range. It teaches a lot of things, discipline and all kinds of things, and folks should do that. Let's not have any accidents. Although accidents that are at the lowest levels ever in history because of, thanks to all of the tens of thousands of trainers out there that are teaching people safe and responsible firearms ownership, and enabling us to make that choice to own a gun for sport or self-defense.
Well, and to give credit where credit is due, a lot of those trainers were trained by the NRA. I'm a National Rifle Association certified law enforcement instructor, for example. So, they do a great job at that and have historically for a long time. I will say it unabashedly. If you just bought a gun and you have no training, you should go get some training. It's not required, and it should never be required. But things that are wise to do are still wise to do. And so anytime you have a tool that's a tool that could endanger someone else if you don't operate it properly, it's a good idea to learn how to operate it. And there's lots of training out there that you don't have to, spend your entire wallet to go get. So if you need referrals or something, contact CRPA, ask them. They'll point you in the right direction. Or you can contact me for that matter.
Training department standing by.
And there you are. Okay, so there you go. So there'll be a link in the description for CRPA. Please check them out. I'm also going to put a link in there for their YouTube channel, because Rick does, along with Chuck and some other people, they do regular updates on what's going on with the law. So I encourage you to watch them. If you just don't want to do it, or you just can't go over there and subscribe, that's fine. Keep watching GunGuyTV. We'll have Chuck back again if he's kind enough to do it. I'm very grateful, Chuck, for your time. Thank you for spending so much time here. I really do appreciate it. And we'll get you on here again, I hope. But
anytime you call, I'll be there.
I appreciate that. I really do appreciate it.
Look at all the things we brought up today that we can do another hour show on.
Yeah, well, I can do many hours of shows on a lot of this stuff.
12-hour day ahead of us.
Yeah, I think so, but I think everybody's fallen asleep at this point. All right, Chuck, have a great week. I'll talk to you later.
Thank you.
Thank you very much for watching. Thank you very much for all of your support. Do look for those links in the description, and wherever you go, whatever you do, please be safe.